is an appeal in the matter of Fasano and Reckitt Benckiser Group Plc.
Good morning. Very good to see you all. Have you had a chance to discuss how the time will be divided between you? What?
We have briefly. May I just, for the sake of form, formally introduce my obviously I appear on behalf of the appellant, with my learned friend Miss Banerjee, who appears behind me on behalf of the appellant. My learned friend Mr. Forshaw appears on behalf of both respondents.
Yeah.
In answer to your lordship's question, we've discussed it briefly, and I was aiming to try and finish by 12:30 to ensure that Mr. Forshaw had half an hour before lunch and an hour and a half in the afternoon, and with the prospect of me having some short right of reply to his submissions. That's of course.
Are you going to deal with all issues in your submission?
I thought it more.
And then Mr. Forshaw with all issues in his, so you have the right to reply on everything. Is that how you're going to work it?
That we didn't discuss. I mean, strictly speaking, of course, you're absolutely right that Mr. Forshaw seeks to defend the original tribunal decision, and while there's no formal cross appeal, he challenges the EAT's decision on justification. I was proposing to deal with my arguments on that as part of my main submissions. I acknowledge that that would effectively give me a right to reply twice. If you wish, I'm perfectly happy only to exercise my right of reply in relation to the question of agency, which is my substantive appeal, and not to trespass on questions of justification, or only to deal with justification.
Well, that would seem to me to be, strictly speaking, we haven't discussed this, but it seemed to me to be, strictly speaking, correct. But we want to hear all the arguments both ways, so let's see how we go.
Yes.
Okay, Mr. Reed.
Thank you very much.
Now, we've read fairly widely into the document. Particularly, we've read both judgments, skeletons, dipped into the supplementary material. So I think we're pretty on top of the issues. For some of us, you'll bear in mind this is a less familiar territory than others.
Yes. So you, at its heart, and I apologise for setting out something which is evident from our skeleton. Obviously, at its heart, there are certain factors which are important in context. The context, of course, is the Equality Act 2010. And as part of the Equality Act, a specific and important area of protection is the protection that extends against discrimination in the context of employment, not only for current employees, but also in relation to former employees in certain circumstances. And at the heart of our appeal, in relation to the arguments which are deployed about agency, is that we say that the tribunal, at first instance, were right to reach a conclusion that the first respondent group company were acting as agent in relation to decisions in respect of a long-term incentive payment plan and how it impacted upon the claimant for the purposes of the Equality Act, and the overturning of that decision by the EAT was an error of law, which leaves one in the unhappy circumstance that if one steps back, one sees the potential that one could have in a group corporate structure decisions which directly impacted upon the benefits or remuneration of employees in that group structure employed by subsidiaries falling outside the protection of the Equality Act, and an area, this being a specific example of protection, effectively being removed from employees in that respect. Now, we say that that's an iniquity of the facts of this particular case that the tribunal correctly found not to be evident, because it correctly concluded, as we'll see, applying the law and looking at the facts, that on the particular facts here, they reached a conclusion they were entitled to reach on the law, that the group company exercised its powers as agent on behalf of the individual employer. The second aspect of the appeal, which we've identified in relation to this at the beginning, is the EAT, and we support the EAT's judgment in relation to this, overturned the decision of the EAT that the PCP, the core element of the indirect discrimination in this particular case, the ET found that that had been justified, and the EAT, we say, correctly concluded that in reaching that conclusion, the tribunal had erred in law in focusing on the wrong legal question, and the AT was entitled to conclude that that was an error which it, at the appellant level, could conclude there was only one substantive answer to once correctly directed as to the law, and the AT was entitled, therefore, to conclude that the policy that had been adopted could not be justified on the facts as found below. I'll very briefly just highlight a couple of the facts. I appreciate from your wide reading that you'll appreciate that so far as the appellant is concerned, he's a former employee of the second respondent, and as part of the remuneration package that he received as an employee, in common with senior employees in the respondent group of employees, he was granted a long-term incentive plan, indeed, in the passage of time, more than one. And in the nature of long-term incentive plans, it provided that if certain performance criteria were achieved on particular dates, then at a subsequent date, an entitlement would vest, in particular to various share entitlements. And there's no issue but that was a valuable benefit. It was a valuable benefit that was conferred on a group of senior employees within the group. It's important in context to recognise this. When one talks about senior employees in the group, so far as the group was concerned, as I understand the position, there was only one employee of the first group company. That was, I think, the CEO, possibly two at a relevant point, but all of the substantive numbers of employees, and critically, all of the numbers of employees who, when articulated as being the legitimate aim of trying to encourage their retention, all of the employees who were beneficiaries under the LTIP schemes were employees of subsidiary companies, including the second respondent here. So, although when we look at the LTIP conferred rights of performance and gave rights over shares in the group, all of the focus of the benefits which were being bestowed for that were at employees of subsidiary companies, one of whom was the appellant. Now, I'm going to take you briefly just to the contract because I want to focus something about the contract to see the relationship. Can I, before I do that, just to make this general observation, there's no issue, of course, but that so far as the relationships are concerned, the ultimate control always rested with the group company because it held all the shareholding through the structure of all the subsidiaries. So in corporate terms, it always exercised power and control as a shareholder. But the reason we look at the contract of employment is that because from the perspective of the contract of employment and the relationship between the employers in the group and the employees, it did not exercise direct control. Control and the relationship of benefits and work was governed by the contractual relationships at the level of the individual employees. So although there's ultimate control...
That's because they're different companies. I mean, it's not... I mean, the group is one company, it's a corporate entity, there's another corporate entity, the subsidiary company.
Yes.
And that is the one that enters into the contract of employment.
Yes, well, I entirely accept that, and of course...
The group decided things at the level of the individual employees, the company and the individual employee entering into a contract.
Yes, well, I entirely accept that. That's absolutely right. And of course, on one level, my learned friend will argue that that means that the separate group entity is obviously, because it's a separate legal entity, a distinct legal entity for the purposes of the exercise of its powers. From my perspective, the importance of that particular situation is that because one's looking at a situation where the relationship is governed between the employer and the employees at the level of the contract. When we're looking at benefits which are being conferred and the wage earnings bargain, it's the individual employer that has control over setting the pattern of that work.
Well, this really lies at the heart of the issue, doesn't it?
Yes.
So should we, you wanted to take us to the contract?
Yes, I think it's helpful to do that. And the contract of employment, you find in tab 1.
Yes, supplementary bundle. We haven't all, not all of us have got tabs.
No, I haven't got any tabs.
The Lord's put tabs in. I know he hasn't. He's put some
I'm sorry, you
bags in.
don't have.
We don't have tabs.
Oh, I do
So go to
apologise.
we're all
That's
working,
fine. I'll work from page references.
We're all
You'll
working
find.
on paper.
I shall ignore tabs and just work on page references.
Thank you.
You
So
find the contract begins at page 2 in the bundle.
yes,
And just for the purposes of note at page 4, we see that the agreement of the contract is between the second respondent, the company, and Mr. Fasano, the employee executive, and various provisions in the contract deal with group companies.
Yes. The appellant had worked for this organisation for some time before this, hadn't he?
He had, yes.
Yes. So there
From
were
memory,
earlier.
I think he'd worked for some 19 years. I
Yes.
think.
So there were earlier contracts with different subsidiaries. Is that how it worked? Just
Well,
in a
there
sentence?
will. We don't have them.
Don't worry about it.
There certainly will be, because at this point in time, he's reached the very senior level in the particular role he is.
Yes.
And this contract is specifically for that particular role.
Yeah.
So what's important, because this contract is dated 2009, is that this is the contract under which membership of the LTIP scheme, it's called the 2017 LTIP scheme because that was the date of its original grant. This is the contract under which his employer would have, as we'll see, exercised a power to that he should have the benefit of that scheme. And this is the contract that applied at the date of the termination of his employment.
Yes.
And so far as salary and bonus is concerned, it's really the separate provision in relation to employee benefits. But if you look at page 6,
Yep.
we have salary and benefits being provided by the company. Sorry, bonus being provided by the company. And then at the top of page 7, you have the subheading employee benefits. The executive should be entitled to participate in retirement, welfare benefits, incentive compensation, prerequisites and other plans and arrangements of the company applicable to senior executives, and the company, of course, being his employer, as in effect and on such terms as prescribed by the company in its sole discretion from time to time. Such participation includes awards granted under the long-term incentive plan of a group company. So the conferment of the benefit, the relationship that decided what was to be put in place, rested solely with his employer. And that is the second respondent. And it's his employer who therefore decided whether there was ultimate holding control in the group, which exercised this for all of the employees in the group. But for contractual purposes in terms of the relationship, it's his employer that's exercised the discretion to confer the benefit that he should be a participant in the group LTIP scheme. And that scheme, of course, on the rules of that particular scheme.
Which words do you rely on precisely for that submission?
I rely on the fact that it says, on such terms as are prescribed by the company in its sole discretion from time to time.
Where are you reading from?
At paragraph 5, and it's
sorry.
the fourth line.
But the scheme was that of the parent company.
I'm sorry?
The scheme was that of the parent company. The LTIP scheme was that of the parent company.
It was, yes.
And it was set up under their rules.
Yes.
Yes.
But participation of it and membership of it rested with the decision between the employer and Mr. Fasano, because that's where we find any entitlement that says, where is this being part of the wage bargain that's being exercised? It's here under paragraph 5. So although ultimately I appreciate that control would always vest up to the group company, at this level, when we're looking at what's being conferred or the relationship, his employer is effectively saying, there is the group LTIP scheme. The rules of that scheme are governed as they provide for discretion within that scheme of rules. And we are saying that you should be part of it, subject to those scheme rules. And that's why we say, when we look at the way that the Employment Tribunal approached it, they were entitled to reach the conclusion that focusing in relation to that relationship at that particular part, we don't need to look at the totality of the relationship, we only need to look at the LTIP, that for these purposes, his employer was the principal, and it was authorising the group scheme, through the group scheme, to provide benefits to him under the LTIP arrangement. For those purposes, it was its agent. That's the heart
other
of
way
what
around.
we say.
Why isn't it that the group makes the scheme, and why isn't it the group that makes the scheme? And what happens here is, if an individual company, the subsidiary, decides to give the benefit of the awards to its employee, it simply opts into the scheme made by the parent. It doesn't authorise the group company to make a scheme. It simply says, if there is a group scheme, you, my employee, will be able to get any benefit from it.
Yes, well, so I agree with that, but that's not really, I suppose, ultimately an answer to my point, because although it doesn't authorise the group to make the scheme, and the scheme exists, the group has chosen to create a scheme in place, it, for the purposes of the relationship with the employee, is the person who says you will be part of that scheme.
Well, it can say you will be part of the scheme, but as a matter of fact, under the scheme of the parent company, the LTIP scheme, does the secondary company have any powers at all?
No,
No.
because the LTIP scheme, which is set up on the rules to govern or deal with arrangements in relation to shares, which ultimately will be shares in the group company, those powers all rest with a remuneration committee that has been set up and created by groups. So it doesn't have power on the individual decision making, but then that's not inconsistent with an agency position, because I may authorise an agent to have complete authority to contract. I mean, one of the difficulties about agency relations is that they have an entirely broad span of circumstance. From one extreme, I might authorise you to be my agent entirely to have independent authority on my behalf to contract legally or take legal steps that commit me, and that's simply the authority that I've given you. To the other extreme, we can have an agent, the classic example is an estate agent, who may have liabilities as my agent in terms of representations which are made or the exercise of action, but typically won't have authority to enter into a contract for the sale of my property. Their agency is more limited. Now, both of those are within the spectrum of agency, but they're very different relationships.
How would you define the agency, the crucial agency relationship in this case for the purposes of your submission?
How do I define it?
Yes, how do you say that? How would you express it on the facts of this case?
I say that on the facts of this case, the group company has been authorised on the basis of the arrangements that have been put in place to exercise powers over the LTIP and the grant of LTIPs on behalf of the employer. So I put it on the basis that what we have...
You say that again, the group company has been
authority,
authorised,
yes,
you said,
authorised to act on behalf of the employer.
You said to exercise powers
Powers over the
over
LTP
the
and the grant
and
of
grant.
awards.
Sorry, I apologise.
You said the group company is authorised to exercise powers
Yes.
over the LTIP scheme and to grant benefits, I think the word would be, on behalf of the employer. That's
Yes.
what you said.
Yes.
Okay, where do we see that authority granted?
Well, we find it in paragraph 5 and in the factual findings that aren't in issue, that what we have in place here is that there was an LTIP scheme. The LTIP scheme had been put in place in 2017, and under the rules of that particular scheme, the claimant was a beneficiary. And indeed, what came to pass is that he ceased to be an employee, and as part of the terms of his severance of his employment, he was treated as a good leaver, which meant that he continued to enjoy rights under
Yes.
the LTIP scheme
Okay.
after the end of his employment.
You must tell me if I'm barking up the wrong tree. Where do we see the authorization? You say the group company has been authorized to exercise powers over the LTIP scheme and to grant benefits on behalf of the employer. That's what you said. Where do we find that authority?
Well, I go back to my first answer, which we find it in 5.
In 5. Where?
Because what we have in 5 is the discretion that's been exercised by the company to put in place benefits, those benefits including the benefits of awards under the long-term incentive plan of a group company, in this case the group itself.
The other problem that I've got is this. Under paragraph 5 of the contract, true it is that your client was entitled to benefits under the LTIP 2017, and he got those benefits, but they were worthless because they didn't meet the performance condition.
Yes.
What we are concerned with is something separate. It is the benefit of amendments made by the group company after the termination of the employment of Mr. Fasano. And I'm wondering how paragraph 5 ceased to apply on whatever date, 30th of June 2019, why they were authorising the group to award benefits for people who had been formerly employed.
Well, so the answer to that is twofold. The first is that obviously he'd been conferred with the benefits whilst employed, and the benefit he'd been conferred upon him was membership of the LTIP scheme under the rules which were applied. So for practical purposes, those are the rules of that scheme. So in answer to your lordship's question, when they exercise their power, and he's a former employee who is the subject of the exercise of the power because he's a good leaver, nothing's changed about the rules. It's an exercise of the rules on the terms as they were originally granted. So there was no sort of change of the powers under the rules. It was the exercise of what was a wide discretionary power.
I thought they amended the rules. He wouldn't have got a benefit under the terms that applied at the time that he was employed, but they changed the rules to say that you'll get 50%, even though you wouldn't meet the performance. So it wasn't under the rules, it was under the amendment to the rules. And the question is, why did the subsidiary company authorise the group company to make changes for people that they'd ceased to employ?
Sorry, can I just separate that out? Because we have to be careful about, and it's my fault, the precision of language in relation to the rules. So there are the rules which define when you are entitled to particular benefit. And obviously, it's entirely right that as it stood at the 18th of September 2019, no employees, whether current employees or good leavers, were going to acquire any rights under the LTIPs to have vested shares because the performance criteria had not been met.
There would be no award because the conditions weren't met.
Correct.
The entitlement, but it was worthless.
Yes. And so what is changed at that point, and whether we characterise it as rules or conditions, what is changed at the 19th of September are the conditions for entitlement, so that the award, 50% of the award is made effectively on the basis that the conditions had been met. So 50% of the award is made even though the conditions have not been met, but subject to the caveat, which is what the tribunal found to be the PCP for indirect discrimination purposes, that would not apply, it would only apply to those in employment on the of a group company on the 19th of September 2019.
Different one. Why would the subsidiary company authorise the parent company on the 18th of September 2019 to make changes in respect of people who had already left their employment in June 2019?
So just going back to my answer. So that's to focus on the change. My point about the rules is that the power that they were exercising to make that change was a power under the rules of the scheme itself as originally set up. So when it was set up in 2017, it included powers which enabled the committee, the remuneration committee of the group, to change the qualification criteria. So the answer to your question is, it didn't authorise, the employer didn't authorise specifically the change on the 19th of September. What it had done is, when it had conferred the benefit of the group scheme with the group scheme rules in 2017, it had given the authority then that enabled a change. So just going back to my example, if in my example I said to you as an agent, I'm giving you the authority to contract on certain terms on my behalf, the conferment of the authority comes at the point that I make that decision or election, or as we say, implied by the particular arrangements.
So, say that again. The point of authority is when?
At the point that I give you, in my example, the point I say that you're going to act as my agent and be free to contract on my behalf.
Yeah.
Obviously.
When's that point? So,
in my example, let's say it's.
No, let's take the facts of this case. When is the point of authorisation in this case, do you say?
When membership of the 2017 LTIPs is conferred on Mr. Fasano by his employer pursuant to clause 5.
Okay.
Because they've given him membership of that scheme, but they've given him membership of that scheme subject to the authority under that scheme to change or vary the rules of the scheme.
Yes. Aren't we looking? You may say I'm being naive and barking on the wrong tree, but aren't we looking for an authorisation between the two companies? When do we see, in order to establish the agency, when do we see the authority arise to create the agency?
Well, so as I say, it's at the point that the company says, the employer says to Mr. Fasano, we are, as part of the benefits that you are receiving as an employee, providing that you will be under the group LTIP scheme. And that authority includes the fact that the group LTIP scheme included the power under the rules to change or vary the entitlements for qualification for the benefits. So there was an authority there that they could change the ground rules.
Mr. Reid, my Lord Justice Baker asked a specific question in respect of paragraph 5. Where in paragraph 5 is that express authorisation?
Well,
if I may, the only reference in paragraph 5 to the LTIP scheme is the final sentence. Is that correct?
Yes, but of course
so
that's
is
only.
That the authorisation?
I don't. When we say express authorisation, obviously I say that the effect of the exercise of that power is that there's an implication of authorisation but the root of the power comes from that particular clause. And I'm allowed to take your point about it only reference in the last sentence. The reference in the last sentence is to give, is to express that it will include that particular provision. So what one's looking at is that the employer has a contractual power, has a contractual obligation to pay salary. There's a bonus provisions in relation to the earlier part of clause, and then it has a contractual benefit as power as part of its authority as employer in the relationship with the employee to exercise a discretion to confer a benefit. And so my point on the authority is that it confers that benefit, and that benefit it confers on terms which include the variation powers under the LTIP. That's why I say the root of the authority is there.
You'll give me the same answer, I know, but just to double check. It says in 5, as are prescribed by the company at sole discretion from time to time. At page 74, we actually have the agreement that was concluded on the 7th of September 2018. And at page 77, we have the terms in relation to LTIP that were part of the termination agreement between Mr. Fasano and his employer. And that sets out his entitlement by reference expressly to the existing terms of the scheme, which didn't yield an award because it was subject to the 50%. There's nothing in that which says, and also, if the rules change, you will get the benefit of any new rule.
Well, that's because the rules are themselves the product of an exercise of a discretion that was vested in the group to create those particular rules. So there's no issue, but there may be an issue in contractual terms, well, other claims, but the group's position, as I understand it, is, and was found by the tribunal, was that it was entitled to exercise powers to change the vesting criteria.
The problem that I've got is this: you want to say the employer, way back when, authorised the company to prescribe a set of rules. But what we've actually got is an employer who contracts with an employee and says, you will have the benefit of certain awards at our discretion. You then, in September, have that fixed when he retires and say, this is what you're going to get. And it happened. It didn't yield a benefit. And then after that, there were changes to the rules. And it seems to me perhaps difficult to say that they were intending to authorise the group company to make further changes to the benefit or detriment of the employee, or whether what they'd actually done was say, now you're leaving, this is the end of the deal between us. It seems odd to leave over, by way of agency, the prescription of post-retirement terms that had been effectively fixed.
Well, I think the answer to that question, is that, let's imagine for the purpose of the thought exercise that he'd not left, and indeed he was with the cadre of people who were still employed. At the point it's granted, and at the 19th of September 2019, when there's a change, your point stands exactly, that he has been granted membership of that scheme on particular terms as they stood at that point in time. But those terms embraced a power of change. We have got the rules of the scheme itself above this. There are pages, the two schemes are at pages 19 to 43 is the LTIP plan 2015, and the LTIP plan 2016 July is from 44 to 68. So there's no issue, but that if he was employed, that might have still been changed, or the ground rules changed, because of course that's exactly what they did. So my point is that the fact that he ceased to be an employee and the fact that he was made a good leaver, which maintained his membership of the LTIP scheme, doesn't change the fact that he was still validly subject to the discretionary power, the employer would say, and when they exercised that discretionary power, it applied to him, and was doing so because his employer had put him in that particular place to say, group will have power and authority over that particular part of your benefits.
You talk about membership, but it's not membership, is it? It's an award under the plan.
Yes.
It's not like joining a club.
No.
So membership isn't the right phrase. The question is whether he's entitled to an award under the plan.
Yes, that's true. That membership may be the wrong phrase. It's an award, but an award that could be changed.
It's an award the terms of which could be changed, yes. And the question is, did the employer authorise the group company to change the terms of awards for an employee who'd already left and with whom they'd finalised the agreement? That's the thing that I find slightly odd. I've no difficulty when you're an employee, because those are the terms that you're applying to him. But when they've left, to say that you're authorising the parent company to regulate post-employment benefits, it seems to be odd.
Can I respectfully observe that the reason that you might find that difficult is that I think that's to phrase the question in the wrong way. Is because you're focusing in the particular perspective at the point at which the exercise happens, to say, well, did you authorise it at that particular point in time, as if there's going to be some separate decision made by his former employer to say, well, yes, we had a retirement benefit arrangements and you're entitled to do that. So my point is different, which is to say the question is not about when, but where they derive that authority from to change the rules. And they acquired that authority from the original rules of the grant back in time.
Could the employer withdraw the authority?
I'm sorry?
Could the employer withdraw the authority?
Well, so we're into an area which the tribunal identified as to whether or not, because the contract does talk about it being the employer's absolute discretion in terms of the conferment of benefit. The tribunal made the point, we would say quite rightly, that if it purported to, the employer purported while he was still an employee to withdraw or vary that particular entitlement when he'd been working in expectation of it, it probably would be a breach of the implied term of mutual trust and confidence.
It wouldn't arise when he's left, of course.
No, because...
So could they withdraw the authority after he ceased to be an employee then?
Well, they couldn't at that point because the terms of his departure had provided that he would be a good leaver and would remain a member of the scheme.
No, be entitled to an award on the criteria then applicable.
Yes, so it's an award on the criteria that had been then made, but what they couldn't change at that point in time was the fact that what they'd given him and confirmed in terms of his retirement was membership, was an entitlement under rules of a scheme that could be changed by the group. And that was a power that they'd had. But just going back to my central point, when his employer provided that he would be given benefits under the group scheme, the central point I'm making is that those entitlements under the group scheme were conferred with the rules of the group scheme, and the rules of the group scheme have the power to vary or change.
Yeah, I've got that point, but what I'm asking is a separate point. Firstly, I did it in terms of was the authority to make post-retirement changes. Another question is, if they are the principal, they can withdraw authority at any stage, and I don't know why it's not an implied withdrawal of authority on the 7th of September when they make it clear these are what you're going to get, not any new changes which benefit you. Why isn't that a withdrawal of authority by the principal? If they're the principal, they decide what to pay. And when he retired, he said, this is what you'll get. You'll get pro rata your existing 2017 entitlements. Nothing there about, but if they change and become more favourable, we'll give you it. or more importantly, that we'll authorise the group to give it to you.
Well, can I split those down and deal with each of them? The first answer is that it's true that they say this is your entitlement, but of course it's an entitlement, going back to the same point without repeating it, subject to variation. They don't need to withdraw an authority or change an authority in any way. They have given the authority. And to go back and to answer your second point about withdrawal, I mean, the nature of agency is that there may be circumstances where you may not be able to withdraw a particular authority to an agent because you may have committed to an enduring position that agent will have permanent authority in relation to. That will depend on the facts. One of the difficulties, of course, that one's faced in looking at that is that the concepts of agent and principal in relation to this are very fluid. And when one looks at Bousted on agency, although there is a chapter looking at aspects of the relationship, there isn't really a clear working definition of the relationship of agent and principal, which applies to every set of circumstances. It will depend upon the particular circumstances that subsist in a particular arrangement. And here I say, and that's why I slightly sort of took issue with the question of express, because I look at an express source for the power, but I do say that there's an implied authority by reason of the arrangement that's put in place when they've exercised that power, because they have put in place an authority that extends to the group company having the power to administer things.
So cutting to it, you are saying it is fact specific. So what we have to do is look at the facts, both as to the rules and how they were applied. Is that fair?
Agency,
Yeah.
it is fair to say it's fact specific, and I say the tribunal properly directed itself as to the legal principles and reached a fact specific conclusion they were entitled to reach, that on the particular fact pattern here, the group company were acting as agent for the principal. So that is, I entirely stand by in relation to matters.
Now, you mentioned the tribunals. At some point, it will be helpful, I think, to look at how the two tribunals dealt with this issue, which would perhaps help to bring it into focus.
Yes.
You're going to do that at some point
Yes,
soon,
I am.
are
Yes,
you?
I am.
I don't want to lead you astray, but for my part, it would be helpful to I make sure I understand the arguments. Having got two tribunals that reach different conclusions, it would be helpful to see how they both analysed it.
Yes. I think it's sensible to do that now.
Okay.
You'll find that in the bundle, the first instance employment tribunal decision is at page 68.
Yeah.
Yes.
And it's fair to say there is more detail in the ET decision than there is in the EAT.
That is true, yes. And it's right to say also, and your lordships don't need to be troubled by this, that at first instance there were a variety of issues, because not only was the question of agency there was more generally the question of whether or not the decision to say we'll vary the conditions to say that the entitlement vests at 50% at this date, but a condition that you have to be in employment, whether or not that was of indirectly discriminatory effect. So the decision looks at the breadth of that, but the appeals, both before the AT and before this court, are of much narrower
Focus.
compass.
Yeah, so it's unsurprising you say the judgment. But where do we go in the ET decision?
Yes. So if you want to find the question, firstly, I'm going to look at the question of agency.
Yes.
And you find that at page 102. Discussion and conclusions.
Yes. Right.
I should say that in terms of the law, perhaps I should have just directed you what the tribunal had before it in terms of at that particular point. If you just go back to 96, you'll see that under the subheading, they summarise the law that they've heard in relation to this. The core provision under section 109 of the Equality Act simply says anything done by an agent for a principal with the authority of the principal must be treated as also done by the principal. You find that at the bottom of page 95. So that was the statute contains no definition of agent or principal, and under agency, before them, their attention was directed to CAME and the Ministry of Defence, the decision of the Court of Appeal under precursor legislation which uses terms of similar effect, and to Blackwood, Birmingham and Solihull Mental Health Foundation Trust. Before this court, your attention is also drawn to a subsequent Court of Appeal decision that deals with the particular section, but which we deal with in our skeleton, that doesn't change the substantive approach. The court also, tribunal below also had its attention directed by respective parties to particular passages within Bousted on agency.
Yes, which is set out there on page 97.
Yes. And then their application of the law to the facts they found begins at page 102 in the bundle. Yes. And at paragraph 136.
Yeah.
And sorry, I'm just tracking the relevant part of my skeleton argument. I do apologise. For your note, we cross-refer parts of this in our skeleton, but the key points here we find begin effectively at paragraph 140. You'll see that the arguments being advanced by the respondents are articulated there, and the focus of the respondents was very much to say control.
And you said consent.
And we said consent,
yeah,
based around the implied conduct of consent. So those were the battle lines, as it were.
And then at 143, the tribunal sets out clause 5 on which you rely.
Yes.
Before we get to that, I do wonder if there's confusion in 142 when they talk about what if they should only be available to male employees. If one company uses a set of terms, I use the terms Midland Bus Company because it's easier, and those terms are discriminatory, pay older people less than you pay younger people, or pay men more than you pay women. The employer is liable because the terms that he's chosen to apply are discriminatory, and that's the end of it. You don't need to get into agency. It's not that the Midland Bus Company is the agent to fix the terms. You have chosen to use a document which is discriminatory. The problem here is the post-employment change. That's the difficulty.
Well, I again, I respectfully don't entirely agree, because
Do you agree
the
with the
problem
first
with
half that normally if an employer decides to use the terms of another employer for its own employees and those terms turn out to be discriminatory, the employer that's chosen to use them is liable because they've chosen to use them, and you don't get into agency at all.
Well, can I just examine your proposition that the issue is that it's a former employee? Suppose, going back to my thought exercise, imagine the situation is that there's exactly this scenario, but there are current employees, and the group company decides in a whim of its own to exercise the powers of changing the crystallisation rights in relation to the share options on the basis that only white employees would be entitled to those particular benefits. An outrageous example of race discrimination. But that is not, you would not be able to say, to take your lordship's observation, that when the company said, here's membership, here are the rights under that particular scheme, you've got those rights. It wouldn't be a case of it adopting a discriminatory position. The question would be whether or not it was liable for that exercise of power by the group company in those circumstances. Now that's true whether it's a former employee or present employee, and the problem which the ET identified in paragraph 42, it isn't entirely a solution because the statute just talks about agent in principle and doesn't define it, is that if you say that there is a separate legal entity within the group structure that on the facts isn't an agent on behalf of the employer, that type of decision becomes there is no protection for the individuals in relation to it.
No, so going back to my first question, do it slowly then. If you employ people and you say the terms of your employment are going to be those set out in the Midland Bus terms, and it turns out that the terms you've chosen, the Midland Bus terms, are discriminatory, is the employer liable because those are the terms he's chosen, or is Midland Bus liable because they were the ones that put the discrimination in the terms?
Well, in your example, it will be the employer, but critically, because at the time you've adopted the terms, they are discriminatory and you've applied them to your staff. Here, at the time that the terms are applied by affording the benefit of the scheme to the employees, including Mr. Fasano, no one says that they're discriminatory.
Nobody applied the new terms of the scheme. This is a problem that we keep coming up against. The company chose as employer to give certain benefits, those described in the LTIP plan as they stood at the time. He left. Changes were made which were more favourable. The employer or former employer hasn't chosen to apply the varied terms. And that's why we're in a post-employment period, is there some way in which you can attack either the rules made by the first respondent because they aren't favourable to former employees, or can you attack the employer for not allowing the changes, the beneficial changes, to be enjoyed by former employees as well as current employees? That's the difficulty, and I wonder whether this shouldn't have been a Section 108 case, not a 109 case.
So
This should be a 108 discrimination by a former employer rather than an agency case in the 109.
well, I think what former employee. So it was phrased, obviously, as discrimination by a former employer, and the former employer liability attaching by the use of its agent. So it always had to be tethered in discrimination against a former employee because at the point it happened, he wasn't an employee. It wasn't run on the basis that, I'll be corrected if I'm wrong, it wasn't run on the basis that specifically his former employer should have said, no, wait, you must do that for all of the people who we've provided for our good leavers under the scheme. And by omission, it was discriminatory. It was always put on the basis that when the power was exercised, conferred, we say, with that authority, without going back on the way I've described, that when the power was exercised, it was a power that was being done so towards the former employee on behalf of the former employer. Sorry, I think we were looking at the Employment Tribunal judgment. My Lord, you took me rightly to say paragraph 143.
Yes, although I do think my Lord's points at 142 are ones we may come back to when we look at the EAT decision. But having flagged that up, 143 is where he sets out clause 5. Yes.
Yes. And as I've articulated, what they look at 145 is at the time of grant, and they they pass on the contractual entitlement in relation to it, other than it being an exercise of the power to grant at that particular point in time as part of his package of benefits because of the possibility of a contractual claim outside the Employment Tribunal. But they make the point there that this formed part of the benefit of the package of benefits that his employer was conferring
Yes.
at that particular point in time.
Why does that involve agency?
Because the conferment of the benefits wasn't simply to say you absolutely get this written in stone. It was to say here are the benefits, but they are subject to these rules, and those rules include a power to change or vary.
Is that what the tribunal decided?
Well, you find at 146 through to 149 how they analyse that particular set of arrangements, and they don't disregard control. They do take it into account, but looking at Bousted, don't regard it as being the greatest significance. But what they look at in 148, is that the basis of the LTIPs is that they're offered to the first respondent to employees of subsidiary companies, such as the second respondents, and it was not argued on behalf of the respondents that the relationship, if it exists, is not a fiduciary one. The question remains whether that's intended to affect the second respondent's legal relations with third parties. So they look at the fact that there's an authority to impact there, and then at 149, they focus on the fact that the power that the group has impacts upon the former employer's legal relationship with its former employee, Mr. Fasano.
Reading all of that, 146 to 150, it appears to be saying that during the whole period of employment and post-employment, the reason why the employee got the benefits was because the first respondent was the agent of the second respondent.
Yes, and it was providing something for the employer's employees on its behalf. That's what they're concluding, and that didn't change when he ceased to be an employee, because the terms of him ceasing to be an employee continue to provide for him being a membership of the scheme.
There isn't a membership of the scheme.
Continue to apply to him having those rights, but subject to the power of variation in relation to those rights. And at one level, if one pauses for a moment and has a look slightly at the other issue of justification, the fact that they're doing this on behalf of the employer is actually completely underlined by their case in justification for changing the rules, because their case for justification in changing the rules is to encourage retention of staff. Well, the group only had one employee. All of the staff were employees of individual group companies. The group company didn't have an employment relationship with them. So when it was changing rules, it was doing it specifically, even at that point in time, for the benefit of the individual operating companies. Because they were the only people who employed people whose retention might be incentivised. And that's absolutely clear from the tribunal's factual findings in relation to this. And just underlining it, the battlegrounds were drawn between us as to how one drew the definition of agency in principle. The tribunal have looked at those principles, and their focus is to accept the argument of the appellant before you that the consent that was being put in place to that authority in relation to its employees, and in the particular context former employees, was something that properly could be described as falling in the principle of agent in principle, so that it was caught by section 109 of the Equality Act.
Is the first sentence of paragraph 48 at the heart of the reasoning?
I'm sorry, the first sentence of
Paragraph 148. Or perhaps the whole of 148. That's where the tribunal seeks to bring the facts of this case within the scope of the bousted
Yes.
approach.
Yes.
The second respondent, the employer, has assented to the first respondent acting on its behalf, and there appears to be no doubt that the first respondent also assents to acting on its behalf. And the whole scheme, given the structure, the scheme was set up for the benefit of the employees of subsidiaries.
Yes. As I say, there's only one employee of Green. So the whole scheme was always focused at the employees of subsidiaries, and within that, a scheme which included the power as part of its scheme rules to vary or change the terms. So that's why I say that I appreciate my Lord Justice Lewis's observations about pre and post, but if one pauses and looks at it while they were employed, that's still the same. It's exactly the same. That the way it was set up meant that in exercising, if they changed their mind as to the criteria for qualification or changed the qualification rights in relation to it, that was a power that rested in the scheme that had been set up. But what had happened is that the employees were with their employer having that provided to them for their benefit, but for the benefit of their specific employers.
There are two separate things. There is the scheme. What are the conditions? What are the benefits? All of that is done by the group company under the rules. That is the scheme. The big question is, does an employee of a separate company enjoy the benefits of that? And the answer to that turns on paragraph 5. Yes, if the employer decides to use and give access to the benefits of that scheme. If no, no.
Yes, and I add to that, which is why I rest on that particular paragraph of the employment's reasoning at paragraph 146. If yes to benefit, yes, but on the terms that that scheme works. Yeah.
Can I go back to? I know it's not helpful sometimes if individual judges take different points at the same time. So I'm sorry, Mr. Reed, but that's how it works sometimes. Can I go back to 148?
Yes.
There, at line 3, there appears to be no doubt that the first respondent also assents to acting on its behalf. Is that right? Was there a doubt? Mr. Forshaw is trying to restrain his facial expressions, which I shall ignore. Was there any doubt that the first respondent assents to acting on behalf of the second respondent?
Well, I think not, because the whole purpose was to provide its benefits to individual employees within the group.
You're saying, in other words, you rest your case on the subsequent parts of that paragraph, the analysis about the whole structure of the organisation.
Yes.
I see. Thank you.
And I say that's the factual findings were factual findings the tribunal were entitled to make, looking at the structure of things, and they didn't err in applying the legal principles to those particular facts in reaching a conclusion that there was agency in that respect.
Thank you. Now, have we
We
looked
want to
at
look at the
everything?
AT, I think we should look at the.
Yes, I was going to say, have we looked at everything on the ET
If
that
you
you wanted to
give me
refer to?
one moment,
On
I think
agency?
That is all that we need to look at in terms of agency.
Yeah, we'll come back to justification,
Yes,
etc.
that's right.
Okay, so EAT, further back in the bundle.
Yeah, it's further back in the bundle, that's correct. And we find the EAT judgment is begins at page 38.
Yeah. Starts off single space, then becomes double space.
Yeah, and the EAT judgment
That's because,
reverses
that's
the
because
approach.
summary is the practice bit.
Yes.
39,
Um,
and the
and-
reasoning at 40.
Agency you find is dealt with from page 48, page 20. Sorry, paragraph 20.
Yeah.
I should say the first part of that deals with whether or not there was a technical issue about whether or not it was cross appeal or not. So you needn't be troubled in relation to that. At page 51 from paragraph 26, we get the summary of the reasoning of the Employment Tribunal.
At 53, we've got 29 on the positions of the parties,
Yes.
the law, and then we have applying the legal principles to this case, page 55, 35 on.
Yes. And so the essential reasoning of the EAT is contained in 35 to 38.
And it's short.
It is short, yes.
What's wrong with 36 then?
So 36, should we go through it?
So 36 is really the heart of it. It doesn't set aside the factual findings which are made. Essentially, what the judge decides is control is the trump here. That the fact that ultimate control rests with the group company as the ultimate shareholder means that there is no control over groups' actions in relation to decisions in respect of the LTIP.
Well, what I read the EAT as saying really is in the kernel of their decision is the second part of that paragraph, where the EAT says, I can see no basis in the facts found by the tribunal for saying that the RB Health authorised RB Group. The second respondent authorised the first respondent to act in relation to the LTIP, or that the group was acting on behalf of RB Health when making changes. So in other words, and then he says that 146 and 148 were of the ET's decisions were assertions rather than reasoning.
Yes, and obviously I say, and this is really the core of this, that when you look at 141, in particular 148, they're not assertions, they're findings that the tribunal is making about the structure and arrangements that have been put in place.
So it's the points that we were looking at in 148 about the structure
Yes.
of the group, a sort of not a shell group, but a sort of a small group with a lot of subsidiaries.
Yes.
That point.
And the way that the tribunal has found that on that structure, the group is conferring benefits down, and that at 148 articulates findings of fact, and that it's it's an error to take the view that what the EAT was doing is a mere assertion there. They're making findings about the structure, and applying the facts. And the way that agency law works is that there really aren't, it's hard to identify particular factors that are universal because they are various in other ways, other than we would say that consent to acting on your behalf is a critical element of agency, that someone is doing something on your behalf, and that control may be a factor in that, and the tribunal took it into account, but actually what they found is a structure whereby there is an assent to group exercising that powers in relation to its employees.
All right, can I just please,
Lady first.
can I go back to the first sentence of paragraph 36? It is plain, if not conclusive, that RB Health had no control over RB Group's actions or decisions in relation to LTIP. Now, I don't think you take exception to that, do you?
I can't take issue with that, no.
So you have, I use the phrase parent group. So you have LTIP is the parent group scheme
Yes,
set up under the relevant rules.
yes.
Right, so that is the scheme. And then do you take any exception to the second, that Mr. Fasano may well have had an entitlement under his contract of employment to participate in LTIP?
I don't, but what the EAT misses here in looking at 146 and 148 is that what they found in the ET is that entitlement under his contract is exercised by the conferment of the particular benefits under the LTIP scheme with its rules. And that's why at 146 and 148, they find that there is, in effect, an assent to the group company providing benefits to the employees on its behalf.
I think we should follow Milady's course, if that makes sense, and go through 136 to see, sorry, 36 to see how much where you part company from the EAT. You don't challenge the first sentence. You don't challenge the first part of the second sentence.
And I don't challenge the third because obviously we say it did have effect on the legal relationship between the employer and
Okay.
and the woman.
So down to the
it's
word
really the
health.
last section.
Well, I've put a line after health at the start of line 5. Do you challenge the proposition that the fact that he had the entitlement and the decisions of the group had an effect on the legal relationship between him and his employer?
No, not at all. And indeed, I rely on that because that's the very thing that a principal will do.
Well, and
will
that's why
find an agent does.
That's why I wondered whether I should draw a line. Then there's this phrase, but that in itself cannot make RB Group the agent of RB Health. Is that where you part company?
I think on the law of agency, it's probably the correct proposition to say just because someone can change another person's legal position doesn't necessarily then mean they're an agent. So I don't disagree.
But you do rely on the fact that happened as part of your case.
I do. Yes.
Yes. You accept that by itself it can't make an RB Group the agent of RB Health, but on the facts of this case, you say that it does.
That's exactly
in the whole
right.
context of the case.
Yes. So I don't say it's absolutely necessary, but on the facts of the case, it does, and that is part of the blocks that the tribunal have found to conclude that agency works.
Okay.
Where I do depart then from, as you rightly identify, if we hold me to my mettle and go through that paragraph, where I depart is from, of most relevance, I can see no basis for the facts found by the tribunal, where I say that's confusing and failing to register that the tribunal has found facts. In particular, it's found facts in 146 and 148, in particular 148.
Can I just question that? Is that correct? Because as you know from the structure of ET judgments, the facts have been found at an earlier stage. 146 and 148 is saying how the facts as found fits into the legal structure. So it's not a finding of fact that they assented in the sense that there was a piece of paper or a telephone call occurring. It is simply saying that from the facts that have been found, I classify or treat that legally as agency. I mean, what is the facts other than the fact that the employee will benefit if the employer chooses in the contract of employment to say you will benefit? That provides the link.
Well, the link is that they've given the authority, the implied authority.
That's the consequence. That's what we want to know. The only facts, there wasn't a telephone call from head office, do you allow me to fix the terms? Nothing of that happened. The only facts that we know and that you've shown us is that there is a contract between the employer and the employee, and that said, at our discretion, we will allow you to benefit from the LTIP prepared by the group company. Those are the only facts. And to say that that's a finding of fact that there's agency is not quite correct. It's saying there is agency based on the fact that you benefit.
Well, I go a little further than that, because what we do know is that is provided to him, because that's the whole point of this case, that he was given the benefit of LTIP awards by the group company. So it's not simply a simple question.
By the employer saying in the contract, you will have the benefits. Those are the facts. You can't ignore the contract. And the only facts that 146 and 148 appear to be based on is the fact that the employer has chosen to allow the employee to benefit from a scheme prepared by the parent company. Those are the only facts. The question is, how do we categorise those facts?
Yes, and I apologise if I seem like a stuck record in answering your question, and undoubtedly I will, is that when they do that, they're not simply saying you get a fixed amount. They're saying you will have that entitlement with those rules, including that particular discretion. So the fact finding is that there is that power for the benefit of its employees, and the fact finding is that they have conferred for the benefit of employees, including Mr. Fasano, who becomes a former employee, a benefit which has within it rules that provide for variation. And so they are giving something that has an entire discretion about change to it. And that authority to change for the benefit is being given to the group, but for the purposes of the relationship between Mr. Fasano and his employer. So
if we were to say, what are the facts found by the tribunal, on the basis of which it concluded that the group had authorised, so that the employer had authorised the group, you would rely on the facts you've just summarised.
you rely on, I'm sorry.
The facts you've just summarised, those are the facts.
Yes.
So when the EAT said there's no basis in the facts, you say, well, looking at the facts that you've just summarised, there is a basis.
Yes, and that's what the tribunal have applied in this particular set of circumstances. So again, it's always dangerous by way of example, but just to take again slightly discordant example, suppose that there are lots of employees in group companies, and one company operates a gym, but other companies don't. And as part of the benefits which other companies provide to its employees, it says you will have access to gym facilities provided by another particular company. Okay? So when one looks at that, I mean, that's a straightforward example, but obviously when it comes to the provision of those particular services of the gym, we're back to a similar proposition. If you've allowed them to operate it, if, forgetting for the moment the Equality Act discrimination about goods and services, if that particular gym discriminated in the way that it provided gym services, the employer has taken for its employees that benefit, and we would say taken for them by way of assent, by the way of the structure, taken it with the discretionary powers which are there about how those services are rendered, and thereby taking on a liability if they're rendered in a discriminatory way.
In this case, not only have they allowed gym access to current employees, and not only have they said you can change, for example, opening hours, for current employees. Also for former employees, because they could have changed things whilst they were employees, if they make adverse changes to former employees after the employment is terminated, you're saying that the former employer and indeed the gym company are liable as agent for any adverse changes introduced after the employment is terminated. That's the problem that you've got in this case. And you say
Yes.
that's fine, because when he was an employee at the age of 18 and he really was going to the gym every day, there was a power to change the opening hours. And once that's exercised, the gym as an agent and the employer, by giving him the power to change the terms, are liable. And presumably the gym could be liable during the course of the employment as well. They could sue the gym.
Yes. Although the way the Equality Act works, both the principal and the agent could be liable for the individual act. But you can't get a liability against the agent without having the principal liability, without having a capacity to have a liability against the principal as your employer.
Sue the gym.
Because it only extends to employers or formal employers.
You could sue the gym.
I'm sorry?
You could sue the gym.
Well, as I say, it's possibly an inelegant example because the gyms are subject to service provision changes, which is a different example. But if I didn't tell a gym, I mean, for example, suppose in the group companies, one of the benefits that was being provided was life insurance being provided by another part of the group. And one of my benefits was that I got life insurance on the terms operated, or permanent health insurance. It's, for me, in relation to this submission, it's the same proposition that the benefit is being conferred on my employees. If I'm conferring that benefit in the terms of those particular rules of that particular benefit, and that includes a benefit to change or modify the life insurance terms or the benefits in relation to permanent health, I, as the employer, have assented to that authority and have to accept the consequences of it in relation to the employee, because it's being directed for the benefit of my employees, ultimately for my benefit.
Okay, well, have we covered everything you wanted to say about the EAT decision on agency?
But bear with me for 30 seconds to say there is
There's a bit more on purposive approach that they go on about.
yes.
He goes on about. Do we want to deal with that?
In terms of purpose for this approach, in relation to that, I say that although the tribunal refer to the purpose of approach, and they've obviously got an eye on the consequences which there might be, and I appreciate in this case, because it's an informal employee, it looks distinct, but the same reasoning applies in relation to my observations that even if it was a current employee, the same thing would arise. They've got an eye, the ET, on the fact that you would leave a hole in employment protection legislation. And we get a reference to purposeful, but I don't say that what the ET do is allow that to cloud their judgment, which is what the EAT suggests in relation to that particular passage. That's at
37 is where the
37,
EAT deal
yes.
with that. Okay.
They say they've been over-influenced, and it's right to acknowledge that the ET looks at the fact that it would be a surprising consequence if a group structure meant that the existence of group parties discriminating in the provision of benefits, in my example of gym membership or life cover or permanent health, fell outside the protection of the legislation. But they don't need to stretch the meaning of the words of the legislation, because on the findings they've made, applying the principles, they reach the conclusion they're entitled to. What I acknowledge is that on the cases, as the case law stands, at the level of this court, there was an attempt in Kemi to argue that there should be a very broad interpretation of agency and principle in a way that departed from the departed from the common law principles in Bousted, and that was rejected by the EA, by the Court of Appeal on the former legislation, and the subsequent case that I mentioned, which is another decision of this court, that decision being under decision with the leading judgment given by Lord Justice Underhill. That's the decision in United and the Union Naylard.
Yes.
That followed the earlier decision in Came. It's worth noting though, and perhaps I should just take you briefly to that authority.
Yes, I've got this. We have got tabs here. This is at tab 10.
It's in this. It's tab 10.
Yes.
And the case, just referring to the facts, the case concerned full-time union officials. Concerned union officials who were lay officials of the union, and a claim had been brought for sexual harassment by Miss Naylard, and one of the issues in relation to the claim was whether or not those officials who were not employees could be agents for the purposes of the union, and the tribunal at first instance had found that they were agents for the union, and that was upheld by the EAT, and this was an appeal by the union to the Court of Appeal,
which failed.
And in the Court of Appeal, the Court of Appeal looks at the case law in relation to agency and principle, and by now, the earlier decision that I mentioned of Keme had been on the precursor legislation before the Equality Act 2010, but by now we're on section 209 that we're focused on here, and you find this being dealt with in Lord Justice Underhill's judgment. It's page 181, and under little a, he starts off with the union's liability for the conduct of the officials, and he sets out there the earlier decision of Keme, in
Yes.
which the two judgments of the Court of Appeal were Lord Justice Elias and Lord Justice Lewison, Lord Justice Kitchen agreeing with both judgments. It's fair to say that Lord Justice Lewison took the approach in his judgment that Parliament had adopted the words agent and principle, and those were legal concepts known to the common law. Absent definition, those are the definitions to be applied. In Lord Justice Elias's judgment, he notes the fact that the way the Equality Act works is that it's actually, on one level, extending liability, because it's making not only the principal liable, but also the agent for the particular action. But he noted also, if your lordships look at page 183, he noted also that that in Keme, Lord Justice Elias, and it's a paragraph 21, when looking at agency in that particular case in Keme, Lord Justice Elias had said, this is in the middle section of paragraph 21, at paragraph 46 he said, whatever the precise scope of the agency concept in section 32, that was a precursor to 109, and in my view it must at least reflect the essence of the legal concept. So Lord Justice Elias had talked in terms of it having the essence of the concept of agent and principle. Lord Justice
No, it's a more purist approach. A more purist approach.
Exactly right.
Well, there we are.
And so that's where the law stood. And in this case, the Court of Appeal didn't have much difficulty finding that the union officials were acting as agents for the union. But it's worth noting,
Does Lord Justice Underhill come down in favour of Lord Justice Elias or Lord Justice Lewis? Let's check.
He doesn't really land in relation to that, although I know that my learned friend will refer to a dicta in the middle case of Blackwood, where he referred back to it being the common law concept.
I hope we're not going to have to resolve this issue. It doesn't sound as though we necessarily will have to resolve it.
I'm not inviting you to do so, because not surprisingly from my perspective, I say that on the basis of the facts and the application of the principles, the tribunal were entitled to reach the conclusion they did.
Yes.
It's worth noting, and this is really one of the problems, and of course it's a problem that has to be faced with tribunals having to make a factual decision looking at the application of this, is that if you look at Lord Justice Underhill's judgment on page 37, having set out, and you'll recollect the way that Bastard works is that it has at the beginning of a chapter principles,
principles, and then in bold, and
then thereafter it elucidates those. And I'm sorry.
I just say this is all very interesting. It's Lord Justice Underhill's very helpful discussion of the law. Where's his ratio? This is Lord Justice Underhill's discussion of the law, which is very valuable and useful. But where's his ratio, his decision?
Well, he essentially finds that by the time it gets to this appeal, the union had started off arguing various aspects of the way that agency might work. By the time it got to the Court of Appeal, their argument was a rather surprising one, that you could only have agency if third parties were actually affected, and that the agent unions here were not, the officials were acting towards a fellow member, not a third party. And even articulating it with due respect to counsel acting on behalf of the union doesn't sound particularly attractive. And that's what he finds doesn't work. He doesn't go into resolving that particular issue between the two.
Okay, so conscious as I am of the time, what is your submission on this case?
My submission on this case, the key point I just draw from this case, which is worth noting, which is really back to why the EAT erred in saying, well, a particular feature here of control is the answer, is points that Lord Justice Underhill notes at paragraph 23 on page 37, is that when you look at the general description in relation to agency as bousted, the authors make the point that the definition of the articles involves choices on their part which are not necessarily, I might be forgiven for putting it in this way, definitive. And there are many of the acceptable uses of the term agency that don't always coincide with each other. See paragraph.
Isn't that obiter?
I'm sorry?
Isn't that an immensely distinguished tribunal, I stress, but it's an obiter observation, isn't it?
Yeah, it is an obiter observation about the problem that in looking at what an agency relationship is, will specifically depend upon your findings of fact in that particular point. So I draw from this the point that it's dangerous to land on one particular aspect of the passages in Bousted and say that that is definitive. And that's why we say that there was an error of the EAT to say, well, because ultimately control rested with the group company, that meant inevitably that the tribunal erred in concluding there was an agency relationship. What Bousted tells us is that in terms of their general definition, it focuses upon authority, whether express or implied, which is where we're back to assent.
Yes.
And then in the body of the text, it looks at different factors.
Yes.
So my short point is to say is that the ET clearly were looking at what they would be directed to look at in terms of the varying factors that Bousted identified and applying those to facts which it is entitled to reach.
Thank you. Now, have we dealt with agency? If so, should we move on to justification?
You may think to death, but I've got nothing else to say.
Very interesting, Mr. Reid. Thank you. No, I'm not being facetious. It did help looking at the way the two tribunals had done.
Yes,
as I thought it would.
and
It helped to focus, certainly my thinking, if you can call it thinking. Now, are we moving on to the next issue, second issue?
yes, if I might just have one moment just to check that I've
Okay.
Fine.
yes
You can.
justification.
Yes, right.
So it's probably just helpful to remember the way that the legislation worked. As I say, most of the facts on this were resolved and not the subject of appeal.
So we go to the Act, do we?
If we just go to the Act briefly,
Thank you.
and we'll find the
11.
Act. The relevant sections in the Act begin at page 210,
Yeah.
and in particular indirect discrimination.
Yes.
And
Yeah.
and for indirect discrimination, the concept requires the application of a provision, criterion, or practice (PCP), as people normally abbreviate it, which is discriminatory in relation to a relevant protected characteristic of the individual employee in this particular context. And here it was age. And subparagraph 2 of 19 identifies when such a characteristic may be discriminatory, and A, B, and C are not the subject of the appeal in relation to matters. So what stands is the tribunal's conclusion that there was a PCP in relation to this matter, and that PCP was applied to Mr. Fasano as a good leaver who remained a member of the LTIP. And just looking
I
at...
hate to say it again. There is no
I'm
such
sorry, I
thing
do
as a
apologise.
member of LTIP. He was a person who had, if we're going to be accurate with the use of language, he's a person who left employment and did so in terms which allowed him to retain any benefit which accrued under the 2017 LTIP. Sadly for him, the benefit did not accrue. So I think going back to membership all the time, it's just using a form of words that just isn't relevant here.
Yeah, well, can I apologise? I don't intend to convey anything by the form of words. I'm afraid it's probably a habit I've got locked into in articulating this. So I'll take the chastisement. If I make the slip again, can we take it as read? That it's not intended to convey anything. So in terms of justification, what's clear is that the PCP having been found and applied, the issue, which is where the appeal rests on, was justification. And for justification, the burden rested clearly upon the employer, although in this particular case, the articulation of it was by the group, because it's a group that formed the policy. And it had to show that it was a proportionate means of achieving a legitimate aim. Now, my understanding is that two aims were advanced: incentivisation of workforce and retention. And the ET found that the PCP, if it had an aim of encouraging retention of workers. And that was what the ET considered under justification.
And helpfully in the supplementary bundle is the statement of Mary Harris and the minutes of the meeting, which really do explain the thinking that led to the decision.
I'm sorry, can you say that?
Certainly, in the supplementary bundle is the witness statement of Mary Harris, the minutes of the various meetings, which demonstrate or show how and why the decision was reached.
Yes, and there's no, that's correct. And the point, so far as the tribunal is concerned, is that they accepted that that there was a legitimate purpose
Yes.
in retention.
Yes.
So the question then became whether or not that could be shown to be, and this is the critical point in the appeal, whether the PCP could be shown to be, whether the criterion that had been applied was a proportionate means of achieving that particular aim. And that's really the point in the EAT, because what the EAT focus on is that the PCP, the thing that put the claimant at the disadvantage, was not changing the rules of entitlement of the vesting so that it vested straight away. What put him at a disadvantage was the rule that said you had to be in employment on the 19th of September 2019.
Except that wasn't the PCP found by the by the tribunal.
That, I'm saying, it was it was.
Well, we're going to have to, once again, I think, focus on the two tribunals' decisions. Is there anything before we do that you want to say in general terms, either on the law or by way of preliminary observation about justification or the defence?
I don't think between us there's anything in relation to justification in terms of the need to show it's a proportionate means of achieving the legitimate aim.
Yeah.
But what's clear, of course, is it has to be directed at achieving your aim. And then the second question is whether or not it's proportionate.
Yes.
And you'll note in our appeal that the EAT takes a view on achieving the aim, and that's the basis of their decision that it isn't doing that. But in the argument before the Court of Appeal, before the EAT, we advanced the argument that the tribunal hadn't really considered proportionality, because if the aim was retention, there were other ways of retaining, encouraging retention, other than changing the rules of the vesting.
Okay.
It could, for example, have said explicitly to all current employees, there is a bonus payment that will be paid if you remain in employment to date X. And that would have, there'd be no issue of indirect discrimination against former employees in relation to that. Or it could have put in place a new LTIP scheme that was only directed towards employees. So there were other less discriminatory mechanisms of achieving the aim of retention.
Well, I think this is going to emerge when we look at the tribunal decisions, the points. So should we do that?
Yes.
Back to then to the ET.
We're back to the ET judgment.
Yes.
And in justification, you find begins page 110. And as I indicated, two reasons were being advanced: incentivisation and retention.
Yes.
And at paragraph 183 through to 190, they don't accept incentivisation as a legitimate aim. And briefly, one could understand that because it was being treated as vested immediately. There was no performance encouragement for people, but they then turn to retention, and they find that retention is a legitimate aim that was being pursued. And you find that at paragraph 191 with their conclusion at 197. And then they turn to proportionality, and that begins at the bottom of page 112, paragraph 109, and they summarise a position which we don't take issue with, and I've obviously identified it. That
Except that 198 correctly sets out the tests for proportionality.
yes. And where I slightly started at your observation, my Lord Justice Lewis, that they hadn't found a PCP.
But they have found a PCP, but not the one you described.
Right. Well, then maybe it's my inadequate language. What I understand them to find the PCP to be that at page 100, paragraph 198.
Absolutely, yes.
Yes.
8
All of it.
and 9.
It's paragraph. Sorry, I said 19. I mean paragraph 199. I'm
Yes.
sorry. Page 113.
Yes.
requiring LTIP participants to be employed as of the 18th of September 2019 in order for them to benefit from the amended performance condition, and that is that you're in place on whatever date in May, 20th of May, when the award is payable. It's two halves: to be in employment with a view to getting the award if you're still there in May 2020.
Yes, although there are two things about that. When you say May 2020, and this isn't changed as I understand it, would still apply even if you weren't there, if you were a good leaver.
Yeah, that's a separate point. But I think all I'm saying is the EAT focuses on how can you be retaining people if the decision is you've got to be in place on the 18th of September. And all I'm suggesting is that wasn't the PCP. The PCP was to be in place on the 18th of September 2019 with a view to getting the amended performance award, which requires you also to be there in May 2020.
I don't disagree with that. The way it worked is that it vested on the 19th of September, but the vesting conditions didn't mean that you immediately exercise the options. Under the rules, you had to be of that particular grant, you had to be in employment in May 2020, or a good leaver, as Mr. Fasano was.
Yeah, that's separate questions. The first question is, do you get it if you're simply in position on the 18th of September? Answer, no, you don't. You have to be in position on the 18th of September and either be working on May 2020 or be a person who's allowed to take a pro rata award because you've agreed retirement with your employer.
Yes, that is true. But, and obviously it's a passing point for the purposes of discrimination in relation to this, there were 6 employees.
Another problem, yes.
6 employees who were on notice and garden leave at that particular point in time, who were in employment at that particular point in time, who clearly were never going to be retained, who were leaving.
There's a problem with those 6 as well, but leaving the 6 aside, it's not a case if somebody was in employment on the 18th and resigned that very evening that they would get a performance award. If that was all that was happened, they wouldn't qualify.
No, I accept that. That if the following day someone had walked out, although they'd been employed on the critical date, they would have been conferred under the rules, but they would not be able to exercise their option because they wouldn't be employment.
They wouldn't get the award.
I'm sorry?
They wouldn't get the award if they walked out on the 20th of September.
Well, I think the award is that the conditions have been met, but they would not. We may be talking semantics. What I entirely accept is they would not be able to exercise powers in relation to the shares and get the shares because they wouldn't be implemented on May the 20th. But Mr. Fasano was a good leaver, and under the rules as they stood, he didn't have to be in employment on May the 20th. He was entitled under the original grant, if that grant had achieved the performance exercise, to the grant on that particular date as a good leaver. The change then obviously changes it by removing the performance criteria, but doesn't remove anything in relation to those who are good leavers for the purposes of the rules. They don't say it doesn't that this doesn't apply to good leavers. They simply say people who are in employment on that particular date. And the EAT's point, and we'll come back to it, because again, I acknowledge it's a short bit of reasoning from the point of view of the EAT, is to say, it's essentially this. What one's required to do with justification is not justify the totality of one's arrangements, but to justify the particular policy criterion or practice that is of discriminatory effect. So what had to be justified, what had to be shown to be a proportionate means of achieving a legitimate aim was 199, not the general entitlement. And so that therein lies the problem, which we say the ET lose sight of in their subsequent reasoning, that they focus on the desirability of generally encouraging people to remain in employment to May 2020 by removing the performance criteria. And they don't focus upon the necessity of justifying the particular PCP. And the particular PCP does nothing towards retaining people so far as Mr. Fasano is concerned.
But the question is whether the PCP is justified, and the PCP is requiring them to be employed as of the 18th of September in order to benefit from the amended performance condition, which requires them to be there either in May or to have agreed terms to leave. And that's what's got to be justified. The fact that Mr. Fasano wouldn't get it can't tell you whether the PCP is justified. If you accepted its retention, not just they're in work on the 18th of September, but they'd be there until the 20th of May 2020, unless they agree to leave.
Well,
that's what's justified.
The answer to that is that if you dissect the PCP, if one says, for example, which is where the tribunal have confused this, if one says that retaining people was making sure that they could see a benefit to be gained by remaining in employment, all they needed to do, which is what they were doing outside this PCP, is to say the performance criteria are, we're treating the performance criteria as met. We're waiving the requirement that we had to achieve a certain level.
For people like Mr. Fasano, they aren't retaining people. They're paying people money when they've already left. And this is to try to get them to stay.
No, but my point is that what they're trying to get people to, they've already committed in with the LTIPs. The LTIPs is there as a scheme. And at that particular point in time, because the performance hadn't been achieved, it was of no value. So it's, I acknowledge and the tribunal recognise that so far as the LTIP was concerned, for those people who could see the achievement hadn't been done, it was going to be valueless at the point that they were in employment at that particular.
They wanted people to stay. They're not getting any LTIP. They want people to stay. So how do they get them to stay? They say, well, don't worry. We won't have to have the satisfaction of the performance condition. If you stay and you're there in May, you'll get 50% of it anyway.
But they didn't need to say you have to be in employment on the 19th of September, because either people had left and were good leavers and might be good leavers in the intervening period of time, or the only people who were in scope were people who were employed. Because
you want a different scheme. They want to keep people. They don't want to reward people who've already left. They want to keep the ones who are still there. And that is the question the tribunal was grappling with. Is it justifiable to think, gosh, we do need people to stay. They aren't going to get any award under the current schemes. We will, when we take our decision, say you can qualify. You're not going to get it if you've already left, because we're only interested in keeping people, and you'll get it if you stay until May. That is retention. If they gave it to people who'd already left, it wouldn't be about retention. It would be partly about retention and partly rewarding people who'd been good employees and had been allowed to retire early.
yes,
That's
but
a different scheme.
well, the difficulty with that reasoning is that we start from the proposition, as I say, that if they wanted the objective of keeping people there, park that at that point in time, they just needed to say the performance criteria are waived, because anyone who was there in the LTIP scheme at that particular point in time would then see, well, actually, I thought this scheme was underwater. I'm now told that if I remain in employment and don't leave, or I'm a good leaver, before May 2020, I will get some economic value.
The problem with
So-
that is they're going to be giving not just the leavers, but the already having left. And not just the stayers, but the left.
Yes,
And they
but-
don't want to do that.
Well, I know, but that means they've got to justify the exclusion.
Yes.
That's the point of the EAT. And the exclusion is not achieving the aim. It's justifying, as the EAT rightly said, cost, which is never in itself a pure basis for justification.
Yeah.
All they're doing, if that's the reason, is to say, we don't want to spend money on people who are former employees who are good leavers. That's not a justification for the policy. That's a justification for why you are accepting part of the policy and doesn't achieve the aim.
Now, I'm conscious of the time. You said 12:30, and we've been interrupting you a lot. All of us have, so it's understandable that you've not quite finished. But I think we need to just focus, if I may say so, on where you say the ET went precisely wrong in its evaluation on this issue, and which part of the EAT's judgment you say accurately sets up the position, if that is your case.
Yes.
I've got it marked by paragraph 217 in the ET. Do you want to say anything about anything before that?
So, two things just about the ET,
Yes.
and I'll come to the EAT because obviously we adopt the reason
Yes.
of the EAT, is that in terms of the ET at 201 through to 203, they're focusing on the overarching scheme rather than the PCP and the justification. And when they look at proportionality, and we say this is a fundamental problem, the fact that even if you apply the scheme with the cutout that they don't want to pay it for people who are good leavers, the problem is that when it comes to proportionality, there are different ways of doing it in a less discriminatory way, because they could have chosen to have conferred a separate benefit or bonus for people who remained in employment to May. They didn't need to change the rules of the LTIP. They could have put in place a separate LTIP scheme, and Mr. Fasano would have had no complaint about that. They don't do any of those things, and that, we say, is the tribunal failed properly to weigh the fact that there were less discriminatory ways of achieving their objective when they look at factors at paragraphs 204, 207.
Yes.
And I acknowledge that they say that it was difficult to see how it could be practically done, but
Yes.
the reality is it could have been done simply as it had been done before by an LTIP scheme or a particular bonus. They also failed to pay sufficient weight to the 6 individuals.
Well, that's
But-
yes. Which I'm hurrying you along. That's
Yes,
covered
fine,
in
it's 209.
paragraph 208 on to onwards.
Yes. And
Isn't the weight then attached to that factor a matter for them? Discretion?
it is within parameters of proportionality. It is an objective assessment, I acknowledge,
Yes.
but it comes back to the same point that I'm making about less discriminatory routes. The fact that you are bringing people in to scope who are on notice and on garden leave, who acquire the benefit for whom you've got no prospect of retaining, shows that your aim of using this is compromised. Whereas a less discriminatory objective of simply paying it only to people who were in employment, not on notice.
Okay. So the fact that the six are normally
Yes.
supports your first point.
Yes.
Okay. And do you want to say anything about what they say about it in paragraph 215 and 216? Odd exceptions and anomalies do not mean that the PCP is not capable of being a proportionate means of achieving a legitimate aim.
Yeah. So I say that the factor they take into account that they've erred in the proper balancing exercise by not properly weighing into account a non-discriminatory mechanism.
Okay.
Really way it is for them, and surely they can do what they've done at 216. Can't they say, well, yes, they should in a perfect world have decided the 6, properly, and they haven't, does that undermine the proportionality of the PCP, as they say, not of the scheme, but of the PCP? And they say, well, we just don't think it does.
Yes, but
What's wrong with them saying that? You may agree with it. I may agree with it. I may not, but it's for them, isn't it?
well, it's an objective assessment that has to be made balancing the particular factors. And obviously, when you're looking at the discriminatory effect, your first question is to say, is it achieving the aim? And we'll come to the EAT and why they think that it isn't achieving that aim. But the 6 compromise the achievement of the aim. Perhaps I've misunderstood your question, but
Well, the 6, they knew about the 6, and they knew a compromise. Well, they knew by failing to deal with the 6, there were some people who were getting it who perhaps shouldn't have got it. And the question is, if you've got a scheme which is aimed at a couple of hundred people, and there are 6 who fall in under the wire, does that mean the whole PCP is unjustified? And they say, no, we're human, mistakes are made, and that's balancing, isn't it?
yeah, so I did understand your point. Well, I take that if you were looking at something that had no other mechanism of achieving your legitimate aim. If there are other ways of achieving your legitimate aim in a less discriminatory way, the fact that you've adopted a mechanism that is discriminatory and doesn't achieve it entirely because you've got people who are receiving the benefit who are not being retained compromises that process.
Yeah, okay.
And this is something which features in the EAT. But,
Okay, well, I think we should go to the EAT now,
yeah, certainly.
if that's convenient for you.
Of course. We're back to page 38 of
And whereabouts in the judge's judgment?
yes, the EAT deal with the question of justification first rather than second, and you find that beginning at page 45 in the bundle, paragraph 13.
Yes.
And what at paragraph 13, the EAT were articulating the arguments I've just been articulating, which were advanced before the EAT about the 6 levers and whether or not the scheme was proportionate means. But what the EAT focus on is the ET's reasoning at paragraph 217, which you find at paragraph 14.
Yeah.
And they focus on whether or not the PCP was achieving the legitimate aim.
Yeah, that was the paragraph which, coincidentally, I had highlighted in the ET's judgment.
Yes. And you'll see at the bottom, the approach of the AT is to say that the change to the performance criteria in the vesting date was both contributed to the legitimate aim of retention, but that it was a specific PCP and not the changes as a whole that needed to be justified. And they note the tribunal recognised that in a different place. Even if it was thought that there was a need for some sort of qualifying or cut-off date in relation to the amended performance condition, the relevant PCP could not contribute to the retention of staff, as the tribunal appeared to recognise in the final phrase of this question. The only real justification of the PCP was to avoid unnecessary payments, and that's really, well, Justice Lewis's point, unnecessary payments to those who were not retained, i.e. to save the expenditure of money. But it was never part of the respondent's case that the legitimate aim of the PCP was to save money, or that they could not afford to pay the participants in the 2017 LTIP award who'd left before the 18th of September. So what the AT were focusing on, we say correctly, was to say, once you've identified the PCP as not being the broader concept of changing the criteria for the LTIP's vesting, but the exclusionary provision, which means that you have to be in employment on that particular date, it's that has to be justified. And what the AT were rightly saying is you can't see that does achieve retention. That at best, it could only be said to avoid paying money to people who are former employees. And that wasn't the way that the case was advanced. The ET were told, as we can see in terms of the reasoning of the ET, it was either incentivisation, which they reject, or retention. So we say that the EAT were entirely right to focus. And I acknowledge again, it's a pithy analysis, but it's a pithy analysis that's right in terms, we say, of justification.
If I may say so, Mr. Reid, when I hear the word pithy or where I read it in a skeleton argument, I think there's always a subtext under pithy, isn't there?
Well,
Perhaps
pithy
he
isn't
says
always
pithily.
bad. With respect to the EAT, they were looking at it and saying, and you'll appreciate that the way it was being argued from the earlier part, that the EAT heard the arguments which I was advancing about proportionality and root and said, we think there's a much more fundamental problem. And you'll note that that in advance of the AT hearing, the EAT had put my learned friend on note that it was taking a slightly different
For the point, Miss Banerjee put forward a lot of erudite submissions, and they decided to focus on something else. Told Mr. Forshaw that.
Yes.
And talk about pithy. Mr. Forshaw's submissions get treated fairly pithily in paragraph 15, don't they? Groundhog Day point.
The PCP is not going to achieve retention in this world. The PCP says they want people to stay, and what it says is to get the award, you're going to have to be there in May, provided you're also there on the 18th of September. It's focusing on the wrong bit. The whole of the PCP is aimed at keeping people in work by saying if you stay till May, you'll get the award, and you've got to have been in employment by definition on the 18th of September. But if you start paying the award, you change the rules and you start paying the awards to people who've already left, then it's not linked. The PCP is not linked to retention any longer, is it?
That's Mr. Forshaw's argument.
Sorry.
Summarise. That's what I thought.
Obviously, I disagree with that proposition for the observation that I appreciate your focus on the totality of it. But the difficulty with focusing on the totality of it is that we're looking at a situation where the factual scenario had people who, like Mr. Fasano, who were good leavers, who were entitled, and the prospect would be that there would be good leavers between 2019 and 2020 who would be entitled. So employment on May the 20th wasn't necessarily the criteria, because you could be a good leaver and still being entitled to that.
When you say good leaver, you mean somebody whom the company has agreed to retire early?
Yeah, well, so I think there are redundancy or other circumstances, but it required...
Redundancy in ill health, actually, there's nothing we can do about that.
It required the company...
In this category, you're talking about people whom the company agreed to early retirement.
Well, for whom the company agreed to treat as good leavers in their departure.
They would have said to Mr. Fasano, you can have the amended awards, but you've got to stay.
Yes.
You can't assume into the new world, when they want to encourage people to stay, that they're prepared to pay the award, even if he's not staying.
Yes. But just coming back to that point, and my retort to the proposition put to me, which is the same as the retort to Mr. Forshaw, is to say, well, we're looking at the aim here, is not paying it to people who are good leavers already or become good leavers, the aim, achieving the aim. If the aim is retention, well, it's not achieving that aim, because your focus is only the people that in employment. It's saving money, which is what the EAT rightly said. What you're doing,
coming back to the, I'm going to bring you back to the EAT. I am conscious of the clock.
yes, of course.
Your argument now was the argument you made, or that Ms. Banerjee alighted on in the EAT, and which is set out in paragraph 16, isn't it?
Yes.
And that's where we see the EAT, and before us, you've got to, I think, say why that's right. So what they said was, yes, they accepted that was the legitimate aim was to retain staff, but he said that is no answer to the claim for indirect age discrimination. They chose to use the changes as a means of achieving the aim rather than as your point, a freestanding alternative scheme.
Yes.
As part of those changes, they introduced a PCP which did not itself contribute to the achievement of the aim at all. It was necessary to justify the PCP, not the overall changes to the LTIP.
And that
that is their reasoning.
yes.
What do you say about that?
And well, obviously, I support that reasoning. I say that is absolutely right. That the EAT has rightly identified that what's got to be justified is the PCP, which is not achieving the aim of retention. At best, it's about achieving the aim of saving money.
We need to remind ourselves that when we're talking about the PCP here, it is in the full terms summarised by the EAT in the passage 199. Thank you very much.
Yes.
In the ET's judgment, that is the full expression of the PCP.
Yes, but remembering that the totality of the changes, which is what the EAT is referring to at paragraph 16, are of course wider, because the totality of the changes, the key bit of the changes, was that they removed the performance criteria.
50% irrespective of performance.
Yes.
Exactly.
And that is what the words amended performance condition at the end of the PCP
Yes.
mean.
And if that had stood, and this is really, I'll conclude on this, but just so we're clear to answer my lordship's question, if that had stood, they achieved the aim of retention because people who are working, who thought that they would, who were employed, have no value out of the LTIP, have learned that actually performance criteria have been waived. So that's achieved by doing that. What's achieved by providing the criteria to say you have to be employment on September 2019
Yes.
is not that. It's, as the AT rightly identified, trying to avoid paying that money to people who were good leavers or former employees. It's not progressing the aim, it's merely doing something else.
Yeah. Thank you.
I wonder if I might just have 1 second to consult with Miss Banerjee, who
Yes.
knows this case far better than
Well, I
I.
was going to ask whether Miss Banerjee wanted to follow or say anything else.
Of course, I should ask if she wishes to say. Sorry, excuse me.
Sorry, right.
It's hay fever, actually. I think. I get it earlier than I get it. My main goes in June.
Right, okay. Is there something you want to say? I'll just leave it there. Sorry, yes, she rightly makes the point. I do apologise. I'll make it on her behalf. She doesn't wish to follow, which is to say that under the settlement agreement, which dealt with his departure, and I don't need to take you to it, what it records is that he is a good leaver, and therefore he remains under the rules. It doesn't change the rules in any
Yes,
way
right.
of the scheme. It's merely identifying under the schemes that he will be dealt with in a particular way.
Yes.
So the employer, at the point of his termination, is continuing to leave him in the scheme, subject to its rules. I think that's going back to the earlier point, but it's important to note that there's nothing
it's
changed.
No,
at that
it's a
point
point. We're grateful to Miss Banerjee for asking you to make that point on her behalf.
As of course am I.
Thank you. Well said, Mr. Reid. Now, Mr. Forshaw, 15 minutes. As extra time is allowed, Mr. Reid. So you've only got 15 minutes before lunch. What do you want to say?
Well, I'll try my best to deal with some brief points in that period, and then to take the matter up
Yep.
again after lunch. I'm going to structure my argument under three headings, my lords, my lady. First, factual points. It is important in my submission to go back to a couple of the key documents in relation to facts. Second, the agency argument, and then the justification argument.
Yeah.
Before I adopt that framework, let me just make 2 points that arise out of Mr. Reid's submissions this morning. And these are overarching points. The crux of this appeal and the crux of this case is that my learned friend says that where an employer or a group company, make no distinction between the two for the purpose of the present point, although there is obviously significant distinction more broadly in this case, decides to make awards or to amend the terms of scheme, in essence, to make retention payments, because that's ultimately what these things translate into, in order to encourage retention, it must not only do that to those employees who remain in employment and can be retained, but must extend that benefit to people who have already left. And I make that point by way of opening because in our submission, it is self-evidently absurd to suggest that in making retention payments or providing retention measures in order to encourage people to stay, you must extend that benefit to people who've left. And that's always been at the crux of our case. Second point is this, and this came out of Mr. Reed's submissions this morning. On the other side, they expressly put forward that they would not complain. Mr. Fasano would have no case if what we had done was to put in place a bonus scheme,
Yes.
making exactly the same payments that were made to those employees who remained, but excluding those who'd left. Or if we had put in place a new LTIP scheme,
Yes.
making payments or awards to those who remained in employment, but not
Well,
to those who left.
Mr. Reed acknowledged that.
Indeed. So that is accepted. And the consequence of that is that this case really is formalistic in extreme. The substantive effect of putting in place a new bonus scheme or a new LTIP scheme, which made that difference between those who'd left and those who remained, would be exactly the same as what we did through the existing LTIP scheme. The employees who remained would have got the same benefits. Those who'd left would have got no benefits. But it is said that because we did it through the existing LTIP scheme, somehow it became unlawful.
So does that analysis mean that it wasn't discriminatory?
Well, we say it is not discriminatory, but we make the point, if you like, as an overarching point, overarching submission from the outset, just to point to the absurdity of the position advanced on the other side. And to point to the formalistic nature of it. If we had done exactly the same thing, if we'd extended exactly the same benefits to those employees who remained and cut out of those benefits those who were no longer in employment, they'd have no complaint. They'd have no case. But because we did it through the existing LTIP scheme, it is said that it's unlawful. That is the consequence of the submission. Indeed, it is the very submission put forward. Mr. Reed said this morning, if they'd introduced a new bonus scheme, they'd introduced a new LTIP scheme, they'd have no complaint. So there it is. I'll move on then, if I may start with the factual points that I wish to advance. Starting point is that the respondents form part of a group of companies. I'm going to refer to them as group and health. I hope, my lords, my lady, that is acceptable. Group is at the top of the chain. Health is some way down the chain. And we can see that from the group structure chart. My lords, my lady, I'm happy if you wish to turn it up. If it's entirely a matter for you, but it's at 181 of the bundle. Supplementary bundle, yes, my lord, quite right. So 181. You've got legal structure, name, and then you've got Reckitt Benckiser Group Plc. That's the top company. And then immediately underneath that, you've got a limited company, a further limited company, Health Holdings, and then underneath that, Health Limited. And those are all 100%.
So what happens? Does Beckett Group people own 100%
Yes.
in Reckitt Benckiser, and then Reckitt Benckiser owns 100% in Health Holdings, and Health Holdings sold 100% of the shares
Yes.
in Reckitt. So there are 4 Vales to Pierce. Not quite Salome, but we're moving in her direction, you say.
Well, indeed. And one can see that from the structure chart at 181, it's got the 100% next to each of them. So they're all wholly owned subsidiaries, but Health is some way down the list. It is an indirect wholly owned subsidiary.
Yes.
Group company, the great-grandfather of this company, then, yeah.
My lord's probably right. I'm not sure I've done the arithmetic myself, but it's some way down the chain.
Right.
So that's the first point on the facts. Second point is that The group company, the ultimate parent company, runs the LTIP scheme. Now, my other friend didn't take you through the rules of the LTIP scheme this morning. I'm going to just spend a little bit of time doing that. There are two versions in the bundle. The first is at 19.
Why are there two?
Well, I think the second is just minor amendments, but nothing turns on that for the purpose of this case or this appeal. But they're both in the bundle. So, but I'm going to spend most of my time talking about the amended scheme. But I'm going to start at 19, which is the first iteration.
Yes.
So one can see, this is the cover page, and one can see immediately at the outset that it's the rules of the Reckitt Benckiser Group 2015 LTIP, and then approved by the directors on the 9th of February 2015, and approved by the shareholders on the 7th of May 2015. So this is a scheme made by the group pursuant to the powers that the directors have under the Articles of Association, and approved by the relevant shareholders as is required.
Drafted by Slaughters.
Drafted by Slaughters, yes. But the reason why I stress the fact that this is approved by the directors and shareholders, and I'll come on to make this point as we move on, is that that is where the ultimate authority for the creation of this scheme rests. Not from Reckitt Benckiser Health, not the indirect subsidiary, the great-grandchild, as my Lord Justice Lewis points out, from the authority that the shareholders and directors have. That is what gives rise to this scheme. I'll jump forward then to the amended scheme at page 44 of the bundle. And there are a few provisions of the scheme that we should consider. In fact, there are 5 points I want to make. The first, my lords, my lady, is to take you to page 48.
Incidentally, I noticed on page 44, the front page of the amended scheme,
Yeah.
there's no reference to director's approval.
Well, I think that's just because it's fallen off because there's no space. It's plainly approved by the shareholders and the directors.
Okay. Which page now? 40?
48, yes.
Yes.
And you'll see the heading granting awards. And it says 1.1, awards will be made by the company or the committee. The company for these purposes is the group company. Group. And the committee is defined as the remuneration committee. And that is the remuneration committee of group.
Yes,
You
quite.
find that at page 46, and it's also in the previous iteration as well.
My lady's quite correct, yes. So the committee is the remuneration committee of group. Moving on to the next provision, and this is key, eligibility. The company may grant an award to any employee, including the executive director, of the company or any subsidiary. So it is group, and only group, that can grant the awards, and they can grant them to employees of the company. And we learned from Mr. Reid was correct to say there are relatively few employees of the company. He wasn't quite correct in the way he put it. There were two, the CEO and the FD, but a very small number. Most of the employees are of subsidiaries. And it is right that, and the rule provides that the company may make awards to the employees of any company or of the company or any subsidiary. So that is where the power to grant awards comes from. It comes from that provision in the rules, and the power to grant awards to employees of subsidiaries like Mr. Fasano originates not from Health, the indirect subsidiary, but from the power granted expressly in the rules that awards can be made to employees of subsidiaries. Third point, and this is the performance conditions. Obviously, this case is to a significant extent about performance conditions. and the variation thereof. Clause 1.4, headed performance conditions. When granting an award, the company may make its vesting conditional on the satisfaction of one or more conditions determined by the committee, at least one of which must be linked to the performance of the company. It goes on to make some provisions about performance conditions, and then picking it up again. The company, with the consent of the committee, may waive or change the performance conditions in accordance with its terms, or if anything happens which causes the company reasonably to consider it appropriate, provided any change performance conditions will be no more difficult to satisfy. So you can change the performance conditions. You can, in effect, you can waive them down but not up. You can't make them more difficult. You can make them easier to satisfy. But it's only the company that can do that. It's any group that can do that, and it can only do it with the consent of its remuneration committee. So the power, the authority to make amendments to the performance conditions rests with group and its remuneration committee. Moving on, one jumps forward to page 50. We have the heading vesting of awards, and 4.1 is timing of vesting. And it says, subject to Rule 6, leaving the group, and 8, an award shall vest on the latest of the following. And 4.1.1 is the date on which the committee makes its determination under Rule 4.2 of the extent to which any performance conditions are satisfied or varied. And then 4.2 below sets out that after the ending of the performance period, the committee will determine to what extent the performance conditions are met. Now, just drawing that together, what happens then is this. The performance period is granted, it's usually 3 years under the rules. At the end of the 3-year performance period, you'll have the financial results. You'll be able to assess, in the performance conditions in this case were earnings per share. So you can assess to what extent there's been a growth in earnings per share. And then you can make a determination, the committee makes a determination as to which, the extent to which the performance conditions are satisfied. And once that determination is made, the awards vest. And that will take place usually in the May following the end of the financial period. Financial period is calendar years, so 3 calendar years. So take the 2017 awards. The 3 calendar years of 2017, 2018, 2019. You get to the end of the financial period on 31st of December 2019, and then the financial statements are approved at the shareholder meeting, which takes place in May. The committee then makes its determination, and the awards vest.
That's why it's May. It's just mechanical.
Yeah.
It's the approval of the accounts by the committee, by the company,
By the shareholders.
by the shareholders, and that's usually in May.
That's usually in May. So the committee cannot make its determination until those have been approved. And
Right, well, I think that's a good place to stop. For short adjournment, look forward to seeing you all at 2 o'clock.
What rise of favour?